Well, good evening, everybody. I do apologise for these sort of very quick fire, one a day videos. I've actually got plans on the next lot of videos already in hand, so I really want to try and get through this, the whole of this motion, as not as quickly as possible. That's not the right word, but you know, I want to keep a nice steady flow of the presentations coming, so that obviously can move on to the next bit and the next bit, and just keep talking about the case, keep looking at different aspects of what we're eventually going to have everything going our way. Anyway, let's look at the next bit. It should all be lined up, ready to go. So let's make sure this is all working right. You know me, I always get a bit concerned about this. Yeah, I think it's working. Good. Okie dokie. Hi, Paul, and Addiction Mouse, and Justice 104 in. You've lost late. Wait, not so sure about that. I'll keep trying though. Shane, I don't recall. Okay, let's pop this up. Full screen should do the job. Yep. So we left off at the various Brady violations. So looking at the next one, the violent porn on the Bobby CD fulfills the Denny motive requirement and therefore meets the materiality standard of Brady. Because the circuit court erred in its finding that the 7 DVDs and CD were identical and therefore there was no suppression in it, never reached the materiality issue of the CD's contents for Brady purposes. Wisconsin statute provides that evidence of other crimes and/or wrongs and/or acts, when offered as proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident, is admissible. The court in Dressler versus McCautry held that the acts admitted pursuant to this section were the defendant's possession of the pornographic videotapes and pictures. Those images depicting intentional violence were admitted as evidence of the defendant's motive, intent, and plan to murder the victim. The defendant in Dressler argued that the videotapes and pictures were irrelevant and constituted inadmissible propensity evidence. The Seventh Circuit disagreed, stating, "The fact that the defendant maintained a collection of videos and pictures depicting intentional violence is probative of the state's claim that he had an obsession with that subject. A person obsessed with violence is more likely to commit murder, and therefore the videos and photographs are relevant." The Dressler court also rejected the defendant's argument that the videos and pictures were inadmissible propensity evidence and held that, although evidence of the general character of a defendant is inadmissible to prove he acted in conformity therewith, the above exception from 90404 was deemed to apply. Dressler is persuasive authority that the same result should occur here. Teresa was killed in a violent and vicious manner. An obsession with images depicting sexual violence against women made it more likely that that person would commit a sexual homicide. The violent sexual images were relevant to motive and would have resulted in trial defense counsel being able to establish motive to meet the Denny standard. As Steve's expert on sexual homicide, Anne Burgess, Dr. Burgess, opines in her affidavit, relying upon 30 years of empirical research literature, there is a well-established causal connection between pornography consumption and violent behaviors. The Brady violations are newly discovered evidence that meet the Brady materiality standard. The decision to grant or deny a motion for a new trial based on newly discovered evidence is committed to the trial court's discretion. State versus Plude. In Plude, when moving for a new trial based on the allegation of newly discovered evidence, a defendant must prove 1. The evidence was discovered after the conviction. The defendant was not negligent in seeking the evidence. The evidence is material to an issue in the case. 4. The evidence is not merely cumulative. The court in State versus Volbrecht stated, at the outset, we observe that the parties pass out the issues on appeal, addressing the newly discovered evidence, third-party perpetrator, Denny evidence, and the alleged Brady violation as if disconnected. However, the overarching issue is that of newly discovered evidence under which all other issues on appeal are submitted. We therefore examine it as such. In this case, the contents of the Veely CD qualify as new evidence because 1. The CD was first disclosed to current post-conviction counsel in 2018 after being withheld for 12 years. 2. Whatever duty Mr. Avery's trial defense counsel was under to investigate the Veely CD was superseded by the prosecution's ongoing duty to disclose and not suppress evidence. 3. The evidence, i.e. recovered pornographic images and 2,632 searches for keywords related to the murder of Teresa, provided by Detective Veely, was material to the trial court's consideration of Denny evidence related to Bobby. 4. The evidence, specifically the aggregated pornographic images and Detective Veely's keyword searches, was not cumulative of the 7 DVDs tendered to trial defense counsel. Rather, this evidence constitutes a unique work product that is not merely a re-evaluation of existing evidence or a new appreciation of known evidence. The CD was material. In order for the defendant to prevail on the third component of the Brady analysis, the suppressed evidence must be material. Citing Strickler, the evidence is material only if there is a reasonable probability that, had the evidence been disclosed to the defense, the result of the proceeding would have been different. It isn't difficult to imagine what Steve's trial defense counsel could have done at trial with the knowledge of the violent pornography searches performed on the computer by Bobby, the state's primary witness. The court in Sims stated, courts must consider the overall strength of the prosecution case, the importance of the particular witness's credibility to the prosecution case, the strength of the concealed impeachment material, and how the concealed material compares to other attacks the defense was able to make on the witness's credibility. Unfortunately, of course, Bobby's trial testimony was completely unrebutted by the defense. the suppressed impeachment evidence contained in the CD was material because it was not largely cumulative of impeachment evidence petitioners had already used at trial, and because the impeachment evidence was of the state's primary witness. Steve Avery had a constitutionally guaranteed right to present a complete defense to the charges against him. Holmes versus South Carolina State versus Pelizano, citing Chambers versus Mississippi. Mr. Avery was deprived of his constitutional right to present a complete defense because of the Brady violation committed by the state in failing to tender the forensic examination CD and report of the Detective Veely entitled Dassey Computer Final Report Investigative Copy. The failure of trial defense counsel to have the benefit of using the CD to establish the Denny motive requirement as it pertained to Bobby and or to impeach Bobby, the state's main primary witness, deprived Steve of a meaningful opportunity to present a complete defense. And I don't know about you, but for me, one of the worst things about this is Kratz trying to pretend that there was nothing on the DVDs and obviously knew what was on them and didn't want Dean and Jerry finding out. And they wouldn't have done had it not been for making a murderer. The cumulative effect of the Brady violations establishes materiality. In addressing a Brady claim, the court is not to view each piece of suppressed evidence in isolation. Instead, the court is required to assess the cumulative impact of all the suppressed evidence to determine its materiality. Kyles versus Whiteley. Suppressed evidence is material if its cumulative effect creates a reasonable probability of a different result at trial, e.g. Gowdy versus Basinger. A reasonable probability of a different result exists if the suppressed information undermines confidence in the verdict. The court in Kyles noted the question is not whether the defendant would more likely than not have received a different verdict with the evidence, but whether it's in its absence he received a fair trial, understood as a trial resulting in a verdict worthy of confidence. A reasonable probability is lower than a preponderance of evidence standard. It is demonstrated where the defense shows that the failure undermined confidence in the conviction, for example, in Youngblood. And, for example, in Byes versus Sheldon, the defendant was convicted for kidnap, assault, and murder. In addressing the cumulative impact of the undisclosed evidence, the United States Court of Appeals for the Sixth Circuit noted that, had the evidence been disclosed to the defense, it would have allowed defense counsel to construct a plausible alternative narrative of the crime. Specifically, witnesses reported seeing a group that may have included the victim taunting Caudray close in time to the victim's murder. Police had determined that Caudray's palm print was similar to the print found at the scene, and one witness noticed that Caudray had injuries to his knuckles after the murder. In vacating the defendant's conviction, the court held these facts, had they been disclosed, would have provided a compelling counter-narrative to the state's theory of the case and could have created a reasonable doubt as to the defendant's guilt in the minds of the jurors. The undisclosed evidence to Mr. Avery would have permitted the defense to construct a plausible alternative narrative of the crime. Certainly a lot more accurate than our corrupt Kratz and Ghan and Ghan and Weigert and Fassbender put together. As stated previously, Kevin Ramlow and Joshua Redant's testimony and the unedited flyover video would have established that the RAV4 was planted on the Avery property. The missing Zipper voicemail and the undisclosed Heitel report would have changed the state's timeline of Teresa's activities and would have provided evidence establishing Ryan as a Denny third-party suspect. The undisclosed Dassey CD would have impeached Body, who was unimpeached as the state's primary witness, as well as established motive to name him as a Denny third-party suspect. The Circuit Court erred as a matter of law in failing to address Steve's claim of ineffective assistance of trial counsel. The standard of review. The 6th and 14th Amendments to the United States Constitution guarantee Steve the right to effective assistance of counsel at critical stages of his prosecution in order to prove that he received constitutional inadequate assistance. Mr. Avery must show that 1. His counsel performed deficiently, and 2. Counsel's deficient performance prejudiced him. State versus Jenkins, Strickland v. Washington. Whether Steve received ineffective assistance is a mixed question of law and fact. Jenkins at citing State versus Domke. A circuit court's findings of fact, including the circumstances of the case and the counsel's conduct and strategy, are upheld unless clearly erroneous. Jenkins citing State versus Thiel. Whether counsel's performance satisfies the constitutional standard for ineffective assistance of counsel is a question of law, which this court reviews de novo. Failure to hire expert. Case law. In certain cases, the duty to investigate includes a duty to consult with and call expert witnesses to testify at trial. Criminal cases will arise where the only reasonable and available defense strategy requires consultation with experts or introduction of expert evidence, whether pre-trial, at trial, or both. Harrington versus Richter. Thus, there are times where the only adequate means of challenging expert testimony elicited by the state is to introduce contrary expert testimony in favor of the defense. Woolley versus Redner, finding deficient performance for the failure to consult with and call a rebuttal expert where there were significant holes in the prosecution's expert conclusions that could only be adequately addressed through contrary expert testimony. Now, several cases in Wisconsin likewise hold that the failure to investigate and or call expert witnesses to discredit the state's case and or to support the defendant's theory constitute ineffective assistance. For example, State versus Zimmerman, where the trial counsel rendered ineffective assistance by failing to call a pathologist to refute testimony that a cord in the defendant's van was consistent with victims' wounds. Likewise, in Thomas versus Clements, the defendant was convicted of intentionally strangling the victim to death. The defendant's defense was that he unintentionally caused the victim's death by putting too much pressure on her neck for too long during intercourse. To rebut this defense, the prosecution relied on testimony from the medical examiner who performed the victim's autopsy. The medical examiner testified that the hemorrhages in the victim's eyes and abrasions to her face indicated that the pressure applied to her neck occurred during an assault and was intentional. The Seventh Circuit held that trial counsel's failure to even consider contacting a pathologist to review or challenge the medical examiner's findings constitute ineffective assistance. Specifically, counsel knew that his client claimed that the death was unintentional and that there were no signs of a struggle. The court concluded that to not even contact an expert was to accept the medical examiner's finding of intentional death without challenge and basically doom the defense's theory of the case. Failure to hire experts. Blood spatter. It is undisputable that the state's blood spatter expert's testimony regarding Steve's blood in the RAV4 was the most critical piece of forensic evidence used to obtain Steve's conviction. The state's blood spatter expert, Nick Starkey, was unrebutted because trial defense counsel failed to present a blood spatter expert on Steve's behalf. On November 16, 2017, trial defense counsel Mr. Strang gave current post-conviction counsel an affidavit admitting that trial defense counsel was ineffective for failing to hire a blood spatter expert. I know that an acquittal very likely would depend in part upon an explanation for Steve Avery's blood being found in the Toyota RAV4, other than because he was in that car himself. To my recollection, I did not consider hiring a blood spatter expert who might have consulted, done independent testing, testified, or all three as to the blood stains found in either of those two general areas of Teresa's car. I did not have a strategic reason for not considering or hiring such an expert or experts. Trial defense counsel committed themselves to one theory about the source of the planted blood by claiming that it came from the 1996 blood vial and was planted by law enforcement. However, trial defense counsel did nothing to substantiate the theory for 8 months prior to trial and at the pre-trial conference on December the 20th, 2006. They declined the state's offer to split the sample and perform simultaneous testing or to join the state in pursuing a single test. Mr. Avery told law enforcement that his finger, which had been cut open prior to Halloween 2005, re-bled on November the 3rd, 2005, and dripped blood in his bathroom sink and on the bathroom floor. Steve consistently expressed his belief to his attorneys and the media that his blood found in Teresa's vehicle was planted and that it came from his trailer. In a recorded interview, he said he dripped blood from his finger into his bathroom sink. Steve's claim that he bled into his bathroom into the sink was corroborated by his blood found around his sink and on his bathroom floor. He told law enforcement and trial defense counsel that as he was leaving his property on November the 3rd, 2005, and exiting onto Highway 147, he observed tail lights of a vehicle close to his trailer. Mr. Avery told trial defense counsel that he noticed that the blood had been removed from his sink when he entered his bathroom early in the morning on November the 4th, 2005. In current post-conviction counsel's motion filed on June 7, 2017, Mr. James, a blood spatter expert, opines in his affidavit that the blood drops and flakes from Steve found in the RAV4 were not from an actively bleeding middle right finger, as the state told the jury. The Sweaty Prize erroneously claimed that the, quote, sheer volume, the sheer number of places rule out that blood in the RAV4 was planted. However, only 1 to 2 milliliters of Steve's blood was found in the RAV4. The experiments conducted by Mr. James with 1 to 2 milliliters demonstrated that the small amount of blood in the RAV4 was selectively dripped in certain places but not others. Mr. James's experiments demonstrate that the blood was not from an actively bleeding finger because there would have been blood in many more places in the RAV4, including on the door handle, key, gear shift, interior hood release, hood latch, hood prop, or battery cable. Suspiciously, there were no bloody fingerprints of Steve in or on the RAV4, despite the fact that he could not have been wearing gloves when he allegedly deposited blood from the cut on his middle finger in the RAV4. Mr. James states in his affidavit that the contact stain by the ignition is consistent with being placed with an applicator. Mr. James opines that the blood flakes on the driver's side carpet rule out an actively bleeding finger because the blood would soak into the carpet and not form flakes on top of it. Similarly, EDTA blood would not form flakes on top of the carpet. Fresh blood dripped in a sink would coagulate in approximately 15 minutes and could form some flakes that could be scooped up and planted on top of the RAV4 carpet. If Steve had bled on the carpet, there would be a corresponding stain under the blood flakes. Additionally, the remaining fresh blood could be removed and planted. In Mr. James's affidavit, he refutes the state's expert, Nick Stalke's testimony regarding the origin of the blood spatter on the inside of the rear cargo door of the RAV4. Mr. James performed experiments which demonstrate that the blood spatter on the inside of the rear cargo door was caused by Miss Halbach being struck with an object such as a hammer or mallet while she was lying on her back on the ground behind the vehicle after the rear cargo door was opened. Mr. James ruled out Nick Stalke's explanation that the blood was from Miss Halbach's hair as she was flung into the rear cargo area. The bloodstain pattern on the panel in the cargo area was the result of the RAV4 being driven while Teresa laid in the cargo area bleeding from a head wound, which created multiple stains as the car moved. The bloodstain pattern evidence refutes Kratz's claim that the pattern was caused by the vehicle sitting stationary and Teresa being thrown in and pulled back out of the vehicle. In a similar case in Texas, the Court of Appeal, Criminal Appeals, held that the failure to challenge the state's testimony concerning blood spatter constituted ineffective assistance of trial defense counsel. Ex parte Abrams. In Abrams, the defendant claimed that she stabbed the victim, believing him to be an intruder. Specifically, the defendant claimed that she was taking a bath when she heard noises in the other room. The state elicited testimony contrary to the defendant's version of events to the effect that blood spatter in the defendant's bathtub indicated that the tub was not wet when the blood was deposited. The court held the defense counsel's failure to challenge the state's witnesses' testimony by, for example, presenting contradictory expert testimony qualified as ineffective assistance. Mr. James states in his affidavit that the most likely source of Mr. Avery's planted blood was from the blood in his sink and not blood from the 1996 blood vial, as trial defense counsel claimed. Mr. James, because of his familiarity with EDTA blood vials, opines that the hole in the top of the 1996 blood vial tube was made at the time Mr. Avery's blood was put in the tube, and the blood around the stopper is a common occurrence and does not indicate that the tube was tampered with. Well, let's hold it there. You know, one thing that crossed my mind as we were reading through that was the little bit yesterday that I looked at with the Occam's razor, and Mark Weigert's, assumption, saying that, the reason why there was no DNA of Teresa or Brendan in the trailer was because they had 5 days to clean it up. Well, with the amount of blood that was shed, if Teresa had been attacked in the trailer and Stephen and Brendan spent 5 days cleaning it up, how did they manage to mix the blood that was in the bathroom? Because they wouldn't have known whether it was his blood or her blood that he'd maybe dripped there. Anyway, just a thought that crossed my mind there. It as I say, it's just bizarre. Anyway, so hopefully we're getting further and further into the this motion. And as I say, I've got some more stuff lined up. I want to look at the other judges that, if you remember, Kathleen petitioned for a change of judge. It would just be interesting to look at who the other judges are in Manitrock. If what Kathleen Zellner asked for was for the case to be taken from Angela Sutkiewiecz in Sheboygan and given to Manitrock. So yeah, it would be quite interesting to see, to do a little bit about the judges. We know quite a bit about the Appeals Court District 2, the Court of Appeals District 2 judges, Lisa Neubauer, Paul Riley, Mark Gundrum, and I think it's a fellow called Jeffrey Davis. But I would quite like to have a look at the... there's a couple of names in the Wisconsin court that are interesting. Anyway, so we'll catch you all later. By the way, if you haven't done so already, do think about getting that book, The Blind Injustice. Absolutely brilliant book. I know that, for example, Dr. Silkman is enjoying immensely reading from it. I know that because I think he's ahead of me, because he was quoting me lines from the book, which I haven't got to yet. So either I'm a very slow reader or Dr. Silkman is a very fast reader. Or, yeah, maybe I'm spending too much time doing these videos. I don't know. But anyway, we'll catch you all again soon. Oh, hi, Mark. Yep. Till next time, it's bye from me and it's bye from him.